in mentioning Part 2, Item Number 1, on behalf of Ms. Dinarity Azu, Senior Advocate. My Lord, today, the matter is fixed for today. However,
one?
Part 2, Item Number 1.
When do you want it?
After 2 weeks,
Heard so and so, as prayed for by MS so and so, Learned Counsel appearing for the appellant, which is not opposed by the Learned Counsel appearing for the respondent, repost on such and such date.
16th of June.
obligement.
I seek your lordship kind indulgence on mentioning Part 2, Item Number 20.
2-0.
Yes, lordship.
Mr. Joseph,
Yes, I'm standing on behalf of my senior, Mr. Joseph, lordship.
as prayed for on behalf of Mr. Joseph Lalchaniema Rentle, Learned Counsel by Mr.
PC Lalmang Iswara.
so and so for the appellant, which is not opposed by MS Linda, Learned PP, repost on such and such date.
18th of June. Daily list for admission, item 1.
Lordship, Part 2, Item Number 17.
In case I go fast, you have any problem now.
Lordship indulgence. Lordship, Part 2, Item Number 17. 17. This is a criminal appeal. However, Lordship, in the paper book, some of the relevant documents regarding the
Paper book
FSL
is
report
incomplete?
incomplete, Lordship. So the registry may be directed to furnish the complete set
Yes,
of
Your Lordship.
paper.
Mr. Johnny L. Toswang, Learned Counsel, appearing for the appellant, submits that the paper book supplied to the Learned Counsel for the parties is not complete. MS Vani, Learned APP, concedes to the aforesaid submission made on behalf of the appellant. Let registry verify and place complete set of the paper book to the Learned Counsels appearing for the parties. Repost on such and such date.
11th June.
I seek your lordship indulgence in mentioning Item Number 5, Part 2. Lordship, the senior Mr. Lelram Tuang, a counsel for the petitioner, had requested me to make a mention on his behalf.
On
Yes,
behalf of the petitioner,
Yes, lordship. He has some medical difficulties, so
your name,
Lalmang Isanga.
as prayed for by Mr. So-and-so, Learned Counsel, on behalf of Mr. Lalrem Tuanga,
Yes,
Learned
Lordship.
Counsel appearing for the petitioner, which is not opposed by the State Council, repost on such and such date.
8th of June. Daily list for admission, item 1.
Mr. Pauto, you are the Legal Aid Counsel here?
Yes, my lord. And my lord, I have received the TCR, the scanned copy of the TCR, and I have perused I have found some discrepancies in the case. So either, my lord, the matter can be taken up today, or perhaps, my lord, may I suggest next week, if it's agreeable to the council, my lord.
No objection next week, anytime, Lordship.
But, in this revision petition, you are challenging what?
Lordship, the discharge order, both the respondents were discharged at the stage of consideration of charge without taking any evidence, Lordship.
You want some more time, Mr. Pauto?
My lord, in fact, I came ready, my lord. I have my citations submitted today, but both the councils have agreed for
All
the
right.
coming week. So
No, if you all are ready, I'm also ready. So I'm just trying to understand what is the difficulty. If you want, we can have it next week, or if you want, we can start the hearing. Because if I take it up, I'll take it up for final disposal.
next week, my lord. If
Next
lordship
week?
permits.
All right. Heard Mr. Johnny L. Toswang, Learned Counsel, appearing for the petitioner. Also heard Mr. L. Pautu, Learned Legal Aid Counsel, appearing for the respondent number 1 and 2. State is not there.
No, my lord.
Not there, Lordship.
As jointly prayed for by the Learned Counsel, appearing for the parties. The matter is posted on such and such date for making an endeavor for finally disposing the criminal revision petition at the admission stage itself.
25th May.
Bye-bye.
Item 2.
Sangi Dinka, just add one more thing. In view of the fact that the case records have already been arrived towards the end. Huh?
My lord,
Yes.
My lord, I was informed that the petitioner, they will withdraw this case, my lord.
But where is the petitioner?
My lord, I've been looking around.
I'll call it again. You get hold of the counsel.
Yes, my lord.
Item 3,
Yes, Mr. Kingte.
Yes, my lord. This matter pertains to a claim for payment of passover of family pension to the petitioner.
Affidavit in opposition has been filed by the state council.
My lord.
You have not filed your rejoinder.
Yes, my lord, the only submission they made is they could not locate the files, the personal files of the deceased.
I don't know that on the last occasion you sought time for filing rejoinder. On 24/2, 2026, it was the learned counsel for the petitioner submits that he may be allowed to file rejoinder.
My lord.
So you are filing or you're not filing?
Yes, my lord, I'll be filing.
As prayed for by Mr. Kingtail, learned counsel appearing for the petitioner, repost on such and such date to enable the petitioner file rejoinder against the affidavit in opposition filed by the state council.
9th of June.
Obliged, your lordship.
Item 4,
Lordship, pleadings are complete. Let the matter be kindly listed for hearing.
Before that, it has to be admitted. What is the case?
Lordship, it is a compassionate allowance.
Compassionate appointment.
Compassionate allowance. Lordship.
Allowance.
Yes.
Where is your prayer?
Page number 17, Lordship.
There has been a delay. Your compassionate allowance claim was rejected because it was filed after 16 years.
Yes.
And you have the CCS pension rules. Please flag 41, rule 41. What is the stand of the state council in your affidavit?
Lordship, we have highlighted at para 7 that he is not eligible for grant of compassionate allowance as per Rule 41 of Central Civil Service Pension Rules 1972.
Why is he not? Because of the delay.
Yes, my lord, because of 16 years delay.
Yes, you read 1441, rule 41, you have it.
Not today, my lord.
Why not today? Why are you all not prepared when the matters are listed before the court and that too for admission? There is another book.
Yes, Lordship.
Yes, you may borrow the book from the court.
Yes, my lord.
Yes, take out rule 41. Read, Miss Caroline. She's Caroline, no? Read it loud.
Yes, my lord.
If you are holding the same book, I think it is page 105.
Page 14.
Yes, sir. Miss Maui, you also don't have it?
Lordship, I have, it's in the page 14.
Read.
Yes, your Lordship. A government servant who is dismissed or removed from service shall forfeit his pension and gratuity, provided that the authority competent to dismiss or remove him from service may, if the case is deserving of special consideration, sanction a compassionate allowance not exceeding 2/3 of pension or gratuity or both, which would have been admissible to him if he had retired on superannuation pension. The competent authority shall either on its own or after taking into consideration the representation of the government servant, if any, examine whether any compassionate allowance is to be granted and take a decision in this regard in accordance with the proviso to sub-rule 1, not later than 3 months after the date of issue of the order imposing the penalty of dismissal or removal from service. The competent authority shall consider each case of dismissal and removal from service on its merit to decide whether the case deserves of special consideration for sanction of a compassionate allowance, and if so, the quantum thereof. The actual misconduct which occasioned the penalty of dismissal or removal from service and the kind of service rendered by the government servant. In exceptional circumstances, factors like family members dependent on the government servant along with other relevant factors. Where an order imposing the penalty of dismissal or removal from service was issued before the date of commencement of these rules and the competent authority at that time did not examine or decide whether or not any compassionate allowance was to be granted in that case, that authority shall take a decision in this regard not later than 6 months from the date of commencement of these rules. No compassionate allowance shall be sanctioned after the expiry of the aforesaid period of 6 months to a government servant on whom a penalty of dismissal or removal from service was imposed before the date of commencement of these rules. A compassionate allowance sanctioned under the proviso to sub-rule 1 shall not be less than the amount
So
of
there is a
minimum-
time limit,
Yes, Your Lordship.
6 months. In your case, 16 years. How do you overcome this? What have you replied to para 7? There cannot be. The ground of rejection appears to be just. I don't find any merit in your writ petition, Ms. Maui. Because there is a statutory time limit, correct?
Yes, Your Lordship.
Admittedly, there has been delay. Because while dismissing, they did not grant you compassionate allowance. Correct? So, in that case, you should have applied within 6 months. But you had approached after about 16 years. So, Miss Caroline, that is the only challenge.
Yes, my lord. And we have also stated in our affidavit in opposition at page 10 that
Where is the impugned order? 28/7/25, Miss Maui.
Yes, Your Lordship.
in order 28/7 with petition.
The impugned order. Where do I find it? 28/7/25. Don't get nervous.
No, 27/8.
28/7. Lordship, the order dated 28/7 is at page number 64.
60?
64.
You were dismissed when? Please give me the dismissal date and the first claim.
Yes, Your Lordship.
I think 20, is it 27809?
Yes, Your Lordship.
When did you submit your representation?
First representation was submitted on the 25th Jan 2025.
Where do I get it?
Page number 38.
1 second, huh? First representation is dated
25th Jan 2025.
20
5th
to 25th,
January
25.
Yes, Your Lordship.
Page.
Page number 38.
So this is, on the face of it, it is beyond the 3 months time. You will come under subsection 2. The competent authority shall either on its own or after taking into consideration the representation of the government servant, if any, take a decision in this regard accordance with provisions to subrule 1 not later than 3 months after the date of issue of the order imposing the penalty. So there is a time limit of 3 months. Now you have applied after 16 years. You have not filed a rejoinder.
No, Your Lordship.
So what is to be done? I see that earlier also you had approached this court.
Yes.
So there the court said the court is not going to go to the merits, but gave you time. Asked the government to reconsider the representation. Correct? What I find, Miss Caroline, is that your representation, how many representations were there? Because what is not clear, the order of this court dated 27/6/25 mentions of 2 representations. It doesn't talk about this 25/1/25 representation. It says the compassionate allowance was not allowed by an order dated 4/2/25. And thereafter, again, a representation was submitted for reconsideration on 28/2/25. Now, in para 7 of that judgment at page 49, this court therefore finds that the said representation dated 28/2/25 should be first disposed of by the concerned authorities. Since the concerned authorities have the duty and the obligation to dispose of such representation, accordingly, the court did not go into the merit and disposed of the instant writ petition with the direction that the authority should dispose of 28/2/25. Now I think the impugned order, where is the impugned order?
28 to 25.
Page 64. So this is done now. It's again reconsidered and rejected. What is wrong? Yes. I'm dismissing your petition.
Lordship, if I may kindly give him time for filing rejoinder.
What rejoinder will you file? The law is clear. You cannot change the facts. You cannot change the facts. It is your admitted case that you have been dismissed on 27/8/2009. It is your admitted case that at the time of dismissal or within 3 months, the state respondent did not grant you compassionate allowance. Your first representation for compassionate allowance was made on 25/1/2025,
Yes.
which was rejected by the government on 4/2/2025. Thereafter, you again filed another representation on 28/2/2025 for reconsideration, which was not done. Therefore, you came by way of a writ petition. In the writ petition, this court says we are not going into the merit because your representation is still pending, and allowed the respondents to take a fresh call. They had taken a fresh call, reconsidered your representation, and passed a final order on 28/7/2025, which is under challenge before this court. We do not find anything wrong in the order of 28/7/25, which is before this court, because that is in line of Rule 41.
Yes, Your Lordship, but still, if I may-
Sorry. You were showing me another paragraph from your affidavit.
Yes, my lord. Page 10. It starts from page 9, para 12.
Yes. Yes.
With regards to Rule 41 of CCS Pension Rules 2021 allows for sanctioning compassionate.
Where are
allowance.
you reading?
Page 9, para 12, my lord.
There's no para 12 in page 9.
Of my affidavit in opposition.
Oh. Yes.
Yes, my lord. Rule 41 of CCS Pension Rules 2021 allows for sanctioning compassionate allowance to persons dismissed or removed from service. The petitioner was awarded a punishment of removal from service via Commandant's second IRBN order number such and such dated 27/8/2009 for his misconduct. The competent authority has commonly sanctioned compassionate allowance to personnel who are deemed deserving of special consideration.
Okay, fine.
Yes, madam.
Heard MS R. Maui, learned counsel appearing for the petitioner. Also heard MS Caroline L. So-and-so, learned state counsel for the state respondents. By way of this petition under Article 226 of the Constitution of India, the petitioner is assailing the impugned order dated 28/7/2025 passed by the respondent number 4, whereby the claim of compassionate allowance of the petitioner was rejected. The brief facts of the case is that the petitioner, who was inducted in the service of constable in the Indian Reserve Battalion, Mizoram, by order dated 14/7/1994, after having served for about 12 years in the said battalion, upon being assigned to undergo pre-induction training course at CIJW School, Verente, during such training, the petitioner having applied for casual leave for 2 days due to personal reasons, the same having not been considered, and thereafter he having left for causal without authorization, later on, while removing 28 numbers of constables of 2nd IR Battalion who, while undergoing pre-induction training course at CIJW School, Verangta, had deserted the training camp area, petitioner also was included in the said list along with the other constables by branding them as deserters. Though later on 10/12/2008, the 29 constables, including the petitioner, were all reinstated into service with effect from 16/1/2009. However, on 27/8/2009, the 29 constables, including the petitioner, were again removed from service by proposed penalty order dated 7/8/2009. Though the petitioner submitted representation for compassionate allowance, the same was declined by the state respondents by their letter dated 4/2/2025. Against the aforesaid rejection, the petitioner submitted representation on 28/2/2025 for reconsidering the claim of the petitioner for grant of compassionate allowance, the same having not met fruits, the petitioner was compelled to approach before this court by filing a writ petition being WPC number 71 of 2025, wherein the learned single bench of this court, upon considering that the representation of the petitioner having not been considered till date, instead of going into the merits of the controversy involved in the said writ petition, deemed appropriate to dispose of the writ petition at the motion stage itself by directing the concerned authorities to dispose of the aforesaid representation dated 28/2/2025 within a period of 3 weeks from the date of receiving the certified copy of the aforesaid order in accordance with law. Accordingly, the respondent authorities on 28/7/2025, after reconsidering the case of the petitioner, particularly the application for compassionate allowance being filed by the petitioner after a lapse of almost 16 years, being statutorily barred under the rule 41 within bracket 1, 2, 4 and 5 of Central Civil Service Pension Rule 1972, rejected the claim of the petitioner. The aforesaid rejection order dated 28/7/2025 reads as under quote unquote page 64. Give the whole order. Situated thus, the present writ petition has been filed. MS Maui, learned counsel appearing for the petitioner, submits that since the petitioner was not granted compassionate allowance at the time of removal of the petitioner from service, the petitioner under Rule 41 of the rules is entitled for compassionate allowance. She further submits that since despite the petitioner having filed an application for reconsidering the claim of the petitioner, the respondent having not done so, this court having directed the state respondents to reconsider the case of the petitioner, it was imperative for the state respondents to reconsider the claim of the petitioner by granting compassionate allowance. Correct?
Yes, Your Lordship.
Full stop. Anything more? That's your submission. Per contra, MS Caroline, learned counsel appearing for the state council, learned state council, contends that the time frame stipulated under the rules, particularly Rule 41 of the rules, mandates that the compassionate allowance is granted within a period of 3 months and not later than and not later than that. Admittedly, neither the respondent authorities, while removing the service of the petitioner, granted compassionate allowance within the period of 3 months stipulated under Rule 41 of the rules, nor did the petitioner submitted any application stroke representation before the respondent authorities for grant of compassionate allowance within the aforesaid 3 months period from the date of removal of the petitioner. She further submits that grant of compassionate allowance while removing the government servant is not a matter of right, but a discretion bestowed upon the respondent authorities, which has to be exercised diligently in terms of the mandate contained under subrule 1 of Rule 41. Okay. Having heard the learned counsels appearing for the parties and having perused the materials available on record, it is opposite to reproduce Rule 41 of the rules, which assumes significance in the case in hand. Rule 41 of the rules read as under, quote unquote. Apparent reading of the Rule 41 that grant of compassionate allowance to a government servant who is dismissed or removed from service is only when special consideration is case specific. Is case specific. In short, if the case is deserving of special consideration, compassionate allowance not exceeding 2/3 of pension or gratuity or both, which would have been admissible to such employee if he had retired on superannuation pension, could have been granted while taking a decision could have been granted on its own by the respondent authorities while dismissing or removing the petitioner or before 3 months from the date of such order. Subsequently, such decision can also be taken after considering the representation of such government servant, provided such representation is filed before 3 months from the date of issuing of the penalty of dismissal or removal from service. The state respondents in their affidavit in opposition have stated as under quote unquote paragraph 7 at page 5 and paragraph 12 at page 9. Admittedly, in the case in hand, the admittedly in the case in hand, the respondent authorities, while issuing the dismissal order of the petitioner on 27/8/2009, did not grant compassionate allowance as the case did not warrant such special consideration. It is further admitted that the petitioner has also not filed any representation for grant of compassionate allowance within the statutory 3 months period provided under Rule 41(2) of the rules. That being so, the impugned order assailed before this court, rejecting the claim of the compassionate allowance claimed by the petitioner, does not appear to be illegal or infirm, does not appear to be illegal or infirm in the opinion of this court. Hence, there is no, hence the aforesaid, hence the instant writ petition is bereft of any merit whatsoever. Writ petition stands dismissed. No cost. Sorry.
Item number 2.
Give this to Dika. Huh?
At the outset, my lord, I tender my apology. I was in court number 1.
You are withdrawing?
Yes, my lord, the petitioner had unfortunately passed away
Oh,
earlier this month. I have the death
give,
certificate, my lord.
give. Mr. Tlana Leonard, yes, Dika. Mr. Tlana Leonard Counsel, appearing for the petitioner, submits that during the pendency of the writ petition, the petitioner expired.
My lord, criminal petition.
Oh, sorry. Criminal petition. The petitioner expired
On 6/5/2026.
on 6/5/2026. In support of the aforesaid, he submits this is the death certificate.
My lord.
The death certificate issued by the Government of Mizoram, Department of Economics and Statistics, LRM Hospital. Accordingly, he seeks withdrawal of the criminal petition. The prayer is not opposed by Mr.
J.H. Rikilal Rothfella.
Sir?
J.H. Rikilal Rothfella.
Ricky.
Yes, ma'am.
By Mr. Ricky and MS Vani Leonard APP for the state respondent. Criminal petition stands dismissed on being withdrawn.
My lord, withdrawal in the sense, as per my understanding, the case has abated.
Okay, stands abated.
Yes, my lord. Obliged.
Item 5.
In view of the expiry of the petitioner, the criminal petitions.
Your Lordship, I appear on behalf of my senior CGC Zaram Sangpui, and I may pray for 2 weeks' time to file affidavit in position.
All right, Sangpui, you're appearing on behalf of Sangpui CGC.
Yes, Your Lordship.
Okay, as prayed for by Mr.
Lian Ming Thanga.
Thana.
Thanga. Lian Ming
Thana.
Thanga.
Thanga.
Thang.
Thanga.
Yes. Yes, Your
Learned
Lordship.
counsel appearing on behalf of MS Sangpui, Learned CGC. The matter stands posted to such and such date to enable the central government, the CGC respondent to file rejoinder in the matter. Correct?
18th of June.
May it please your lordship, I'm appearing on behalf of my senior Samuel Vanar Shieta, who is on lex on the other court, my lord. We are appearing on behalf of NHIDCL respondents 10 and 11. Your lordship, we have filed our affidavit in opposition, my lord, your lordship.
It appears that your name,
Philip Vanmal Sova.
so and so, appearing for the respondent NHIDCL, na?
Yes, my lord.
Submits that the affidavit in opposition on behalf of the respondent NHIDCL has already been filed. It appears that the same is on record.
Item 6.
Lordship, this is a MSCT appeal.
Statutory appeal, I'll admit it.
Yes.
Why don't you change them? Change them. This order you can. Your name,
Kerala, Indiana.
so and so, admit notice 3 weeks, call for case records.
Your lordship.
23rd of June. Item 7.
This is also statutory
Yes, your
appeal.
lordship. Yes.
Okay, same.
Thank you, Lord.
Item 8.
Regular first appeal.
Yes, Your
This is
Lordship.
also statutory appeal.
Yes, Your Lordship. Lordship.
I'm admitting it. I'm just waiting for the change of the stenos. This is statutory appeal. Huh? First appeal, admit 3 weeks, call for case record.
Your Lordship, may I pray interim order.
Interim.
Interim order to stay.
Where is you have filed an IA?
No, Your Lordship.
But whether an IA will be required, we will also issue notice on interim.
Okay.
Yes.
22nd June. Item 9.
Please, Your Lordship. My Lord, the learned main counsel is unable to appear today.
Yes,
due to
Mr. Lalamanga.
Yes, Your Lordship. Your Lordship, I have no objection. We have already filed our written objections
No
against the two.
objection to what?
No, they are praying for adjournment, my lord. I have already filed my written objection
The
against
IA is for what?
one of the IAs is for producing additional affidavit. Another IA is for depositing the amount of money already withdrawn. After I have
You are
obtained-
having objection.
Yes, I am having a strong objection, my lord.
Strong objection.
Yes.
As prayed for by Mr.
Samuel Alampuya on behalf of
Samuel Lalampui.
Puya.
Puya, learned counsel appearing for the applicant, which is not opposed by Mr. B. Lalramanga, learned counsel appearing for the respondent, repost on such and such date.
11th of June.
Much obliged, man.
Item 10.
May I plead your lordship?
I can't see anyone on the screen.
May I plead your lordship?
Yes, Mr.
Vikas Jammar, your lordship.
Jamir.
Jammar.
This is item number. Zamar. Yes.
Jammar. Item number 10, your lordship.
Yes, Mr. Zamar.
Your lordship, at the outset, I would like to place one information before your lordship that on the last occasion the case was listed for case diary. But in
Yes.
the meantime, charge sheet has already been submitted by the investigating officer. So if the TCR is available, I would like to proceed with my submissions.
Your Lordship, we have to call for the decision.
We'll have to call for it. It is submitted at the bar that in the meantime the charge sheet has been, the case has been charge sheeted, correct?
Yes, Your Lordship.
Let the scan copy?
Scan copy.
Let
will
the
do.
scan copy of the case records be called for, refix on such and such date.
2nd of June.
2nd June?
Second, you much obliged, but I would like to make one more submission, your lordship.
Yes.
Do I have to submit IA
IA for what?
for submission of charge sheet, copy of the charge sheet?
No need. IA is required.
I don't think so, Your Lordship.
Sorry?
I don't think so, Your
Yes,
Lordship.
you will have it. I have already called for the case records. The charge sheet will come with it.
Much obliged, your lordship.
Isn't it, Miss Vani? That's
Yes, Your
so.
Lordship.
Should we say scan copy of the TCR containing a copy of the charge sheet?
Yes, Your Lordship.
Huh? Containing of the copy of the aforesaid charge sheet filed. Okay? It will come.
Item 11.
Your Lordship, in this matter is handled by Miss Mary. However, she is not well. And
She is
couldn't
not
appear.
well or her daughter is not well.
Both of them were not
Both
well.
are not well.
Yes.
Because yesterday before the division bench, someone mentioned about her daughter. All right. So, Mr. Laramanga,
Yes, my lord. This, if possible, this may be taken up next Tuesday, my lord.
I have no problem.
Yes, I have talked to Miss Mary also, my lord. Mrs. Mary also.
No, but now Wednesday. One difficulty is that the next Tuesday there could be a division bench instead of Wednesday, because Wednesday is a holiday. But we can keep this if you want. I can keep it. Only thing, then you'll have to wait.
Yes, we may keep it, your lordship, because I'm having personal difficulties for this coming Thursday. I'm so
All
sorry
right,
to
all
say
right,
that.
all right. Heard Mr. Abil Lalremangal, Learned Counsel appearing for the petitioner. It is submitted at the bar that that MS Mary, Learned APP, due to her health issue, is not available before this court today. However, accordingly, the matter stands reposted on such and such date.
26th May.
Much obliged.
Item 12.
But Miss Vani and Miss Linda, in case on the next day also Miss Mary is not well, then I think one of you can always, because these are bail matters, it should not. So that's why I'm not insisting you today, because but next on Tuesday you look into it, huh?
Your Lordship, appearing on behalf of my senior as Vanlesheta, the leading counsel of this regarding this matter, as he could not appear
Leading
today.
counsel? Is she a senior designated advocate? Conducting counsel?
No, Your Lordship. My senior, he's my senior.
Your senior, but is she a designated counsel?
No, Your Lordship.
A senior, it is only you are led by a senior designated, unless, and if it is and if she is your senior, then she's conducting counsel. This is the correct term generally used.
Yes, Your Lordship.
I'm only saying it to you.
Thank you, Your Lordship.
Yes,
Yeah.
yes.
So
you want some time today?
Yeah, yes, Your Lordship.
Why?
Because
You
as-
press it, it's a bail application. Yes, what is this bail? Under what provision?
48, Your Lordship.
21C.
Yes, Your Lordship.
Ms. Vani?
Yes, Your Lordship. This matter is handled by Miss Mary,
Material,
actually.
huh?
This matter is handled by Miss Mary as well.
Oh, as jointly prayed, repost on such and such date.
Your Lordship, if this matter may be taken on 2nd of June, if it pleases Your Lordship.
2nd of June. Hearing list, item number 4.
Miss Linda, you are there?
Lordship, this is an appeal against the conviction order dated 23/11/2023. Passed in Lunglei.
21C.
Yes, Your Lordship.
Paper book is there?
Yes, Your Lordship.
Yes.
Firstly, Your Lordship, the ground is that there was violations of section 41 and 42 of the...
You are Jonathan?
Yes, Your Lordship.
There is what?
Violation of sections 41 and 42 of the NENPS Act.
41 and
42. Regarding information and arrest of the petitioner, appellant.
Yes.
Yes, Your Lordship. In this
NDPS
case,
Act.
it is... Yes, Your Lordship. In this case, information was given by one ASI Sila Remruata of CID to the Lunglei Police Station on 27th of June 2020. And in that instance, information was taken down in writing by Inspector C. Ramnun Moyi, which is at page 41 of the paper book. Thereafter, authorization was purportedly issued by the concerned OC immediately. And acting upon the authorization, the search and seizure was conducted. However, Your Lordship, in this connection, it is submitted that the evidence shows that the evidence of the said Sila Remruata shows that the OC was not present at the time when he was reporting the incident to the concerned police station. So it is my submission that authorization was not given at the time of the arrest, at the time of information, when information was recorded. And secondly, Your Lordship, there are violations with regard to section 52 and 52A of the NDNPS Act, as well as the NDNPS rules, Lordship. Firstly, as stated in my memorandum of appeal, there were no marks, numbers, or identifying particulars mentioned in the inventory form. It was alleged that the seized articles was recovered from one brown rucksack, one brown bag, but no mention has been made regarding the brown color bag in the inventory form, as well as the report of seizure and arrest. Your Lordship, also, the inventory photographs do not establish any connection between the instant case and the seized articles. Just a bunch of police officers sitting in a room with some soap cases was shown in the inventory photographs, which does not mention anything about the case. And the charge sheet does not contain a list of samples drawn, which is mandatory in such cases. Hence, there is no proof that the samples which were actually drawn from the seized articles. Moreover, Your Lordship, the judicial magistrate before whom the samples were allegedly drawn was not examined in the court. Hence, Your Lordship, my submission is that since there is no nexus between the photographs as well as the seized between the photographs and the seized articles, and the absence of the list of samples drawn, and the fact that the judicial magistrate was not examined in court, there can be no ground for conviction of the accused.
No nexus between the photograph of the sample.
Inventory photographs.
Huh?
Inventory photographs.
Inventory photographs.
As well, no nexus between the inventory photographs and the seized articles.
Number one. Number two.
Number two, judicial magistrate was not examined.
Who was at the time of seizure?
At the time of drawing of samples.
And number three,
list of samples drawn has not been included in the charge sheet.
Not exhibit.
Not exhibited. It is not there in the charge sheet itself.
Yes, and you were saying something about authorization?
Authorization is that information was taken down in writing, and authorization was purportedly given by the concerned OC. However, the evidence of the person who gave the information stated in his cross-examination that the OC was not present at the time of reporting the incident till the time he left the police station. So authorization must have been given after the seizure and arrest was made. So which makes the entire process illegal.
All right.
Apart from this, Your Lordship, the brown bag from which the essay was recovered has not been mentioned in the seizure and arrest memo, as well as in the inventory form. And Your Lordship, in the evidence of the prosecution, none of the witnesses have claimed that they were the authority who drew the samples before the concerned magistrate. None of the witnesses were responsible for drawing the samples.
Let us read the evidence.
The evidence is from page.
Let's see. You start from the beginning, no?
Page 22 onwards, Your Lordship.
Before that, what is the inquiry report, page 1? You go by seriatim, it's a criminal appeal, so you'll have to place everything.
Yes, Your Lordship.
This court will have to now reappreciate and appreciate the facts, right?
Yes, Your
So you
Lordship.
place everything.
The inquiry report was prepared by Inspector C. Nunmoy, who was the person who took down the information in writing after receiving it from CLR Maruata. If I may read, Your Lordship. I have the honor to state that on so-and-so, while I was on duty at Lunglei Police Station, ASI CLR Maruata of CID SB Lunglei appeared at the PS and verbally reported that they had detained one person who was suspected to be carrying some contraband items at Rasiveng, Lunglei. Information report was prepared and the matter was also conveyed to the OC, Lunglei Police Station, and as per authorized by OC self with party rushed to the spot to take necessary inquiry. On reaching at the spot at Rasiveng, Lunglei, one person, PC Ramnun Moya, son of so-and-so of Rasiveng, Lunglei, was found detained by CID staff, Lunglei. Two reliable independent witnesses, Arl Sang Moya, so-and-so, and Vanal Ruata, so-and-so, Lunglei, were requested to witness while conducting search of the suspected rucksack, dark brown color. I informed the detainee his ground of apprehension and informed him that he was suspected of carrying some contraband drugs, and I observed the formalities and prepared grounds of belief at the spot in presence of accused and reliable independent witnesses. After that, I conduct searching his rucksack, dark brown color, in presence of reliable independent witnesses, and found 28 soap cases wrapped covered with black sellotape. After opening the 28 soap cases, suspected heroin was found, which was smartly packed in a transparent polythene in all the soap cases. All the 28 soap cases suspected to be heroin are taken out from the boxes and weighed it as given below. And at page 2, Your Lordship. All the suspected contraband heroin totally weighed 351.5 grams and value in local rate rupees 28 lakhs. The suspected contraband heroin were kept in the same rucksack, which was packed and sealed properly in presence of reliable independent witnesses in the bag zipper. The said articles were seized in the presence of accused and the reliable independent witnesses. After observing all formalities, the apprehended person, PC Ramnun Moya, along with 28 soap cases containing suspected to be heroin, was brought to Lunglei Police Station. All the seized contraband drugs suspected to be heroin are kept in Police Malkhana White NDPS Malkhana register so-and-so. Therefore, I request you to kindly register a case against so-and-so under the appropriate section of law.
So this was found from the bag
Yes, Your
he
Lordship.
was carrying, isn't it?
Yes, Your Lordship. that was the case of the prosecution. However, Your Lordship, one of my contentions is that no mention has been made of the bag in the report of arrest
He
and
was
seizure.
traveling in what?
On foot. He was detained by the CID members, apparently.
Yes, then
And then one of the CID members had gone to the police station, and then he reported the case to the Inspector Siram Nunmoy, who took down the information in writing.
in your 313 you said even I was I was not brought. What is your defense? Okay, anyway, we will come to 313 later. First, come to the fact. Page 22.
Yes, Your Lordship. 22 is the evidence. This is the position of Inspector Siram Nunmoy, who took down the information in writing. If I may read, Your Lordship.
Yes, please.
I know the accused P. Siram Nunmoya, who is produced before court through WhatsApp video call. During the year 2020, I was Inspector of Police and posted at Lunglei Police Station. On so and so, while I was on duty at Lunglei Police Station, ASI Sil Remruata of CID Lunglei appeared at the PS and verbally reported that they had detained one person who was suspected to be carrying some contraband substances at Rasiveng Lunglei. The said information was recorded and was conveyed to the OC Lunglei Police Station, and as per authorized by OC self with party rush to take necessary action. On reaching Rasiveng, we knocked the door of about 3 houses to get witnesses, but in vain, as it was during total lockdown due to pandemic and it was raining at late night. Then we called a nearby resident, namely Vanal Ruat of Rasiveng, who is working as a traffic police, and requested him to call civilian witnesses. He brought Arlel Samoya with him and told me that he could not bring other civilian witnesses, and we moved towards the spot. I then requested him to witness the search with Arlel Samoya. On reaching the spot, one person named P. Siram Nunmoy was detained by CID staff Lunglei at the construction site of PH Lalzota, Rasiveng. The accused was carrying dark brown color rucksack on his back, and I informed the ground of apprehension and further informed him that he was suspected of carrying some contraband drugs. I stated to the accused and witnesses that there is no time to obtain search warrant. Hence, I prepared grounds of belief and they put their signatures. Before conducting search, we the searching party offered our body to be searched by the accused, and he thoroughly searched our body by saying that carrying hello. I told him to put the rucksack down on the floor, and then we conduct search of the rucksack of the accused in presence of accused and witnesses under proper light. Inside the bag, there were 28 soap cases of different colors covered with black sellotape. The soap cases were opened one by one, and inside each of the soap cases, there were transparent polythene packets containing powder. Weighing was done on the spot. The total weight was around 351 grams. I then seized the contraband drugs in their presence. The powder were repacked and sealed with wax. The 9 green color soap cases were marked as A1 to A9. 8 numbers of red color soap cases were marked as so and so. 7 numbers of blue color soap cases were marked as so and so. 2 numbers of blue and red color soap cases were marked as so and so, and 2 numbers of green and red color soap cases were marked as so and so. I prepared seizure memo on the spot, and I put the seized 28 soap cases of suspect heroin in the same rucksack, and the said rucksack was sealed with wax. I prepared a rough sketch map of the PO. After observing all formalities, the apprehended person, P. Siram Nunmoy, along with 28 suitcases containing suspected heroin, was produced to Lunglei Police Station. The seized suspected drugs were kept in police Malkhana White, Malkhana register so and so. I examined the informant and seizure witnesses and recorded their statements. Then I submitted inquiry report to OC Lunglei Police Station. And cross-examination is at page 25, Your Lordship.
Yes, keep reading.
Yes. It is a fact that I do not give intimation to the relative of the accused on the same night. It is a fact that the accused was detained by some other person on the place of occurrence, but I do not know who they are, other than they are CID personnel. It is a fact that the seizure form was not stamped with specimen seal. After submitting FIR along with seizure, I did not take any further action in the instant case. While search and seizure was conducted, there is no other gazette officer.
So here, this accused was already detained.
Yes, detained
before
by.
PW1
Yes, Your Lordship.
came, no?
Yes, Your
He
Lordship.
was already kept. Now, who detained? Who caught him?
As per the case, he was detained by some CID personnel.
That is not examined. That
Yes,
person is not
They
examined.
were not examined. One of the persons who detained them was apparently Sila Remruata, who had gone to the police station to report the incident.
That is there. He's examined.
Yes, Your Lordship. But while he was in the police station reporting the incident, the people who had detained the accused were not examined.
No, what I am asking is that the persons who caught him,
Yes, Your Lordship.
anyone has been examined or not?
That Sila Remruata has been examined.
PW?
This PW number. PW number 4.
Okay. All right.
I'll continue, Your Lordship.
PW4.
Yes, that is at page 32.
There's no PW4.
No, after the defense evidence at page 32, Your Lordship.
32 is DW. He's defense witness. C. Lalim Ruata.
That is PW, Your Lordship.
Huh?
PW.
Page 32 is PW.
Yes, Your Lordship. Before that, there was one DW. There's been some mix up with the page numbers.
Okay. All right. Yes, go on.
Yes. From para number 4, Your Lordship. After submitting a FIR along with seizure, I did not take any further action in the instant case. While search and seizure was conducted, there is no other gazette officer. When we rushed to the place of occurrence, we brought weighing machine along with us. Accuracy of the weighing machine was not tested before weighing the seized article. It is a fact that seized article was covered with transparent polythene inside the bag carried by the accused, and inside the transparent polythene it was separately packed in soap cases. The seized article was recovered by me in the presence of accused and civilian witnesses. As per my view, the color of the seized suspected heroin is light brown. And there is one re-examination at page 26. Since I did not arrest the accused, it is not my responsibility to intimate the relatives of the accused. That is the evidence of Siram Nunmoy, who is also, Your Lordship, purportedly the seizing and arresting officer. However, in her...
Caesar. PW 2 and 3 are the Caesar witnesses.
Yes, Your Lordship. However, Your Lordship, if I may take you to page 26, the re-examination.
Yes.
He was the one who conducted the search and recovery, as well as the arrest of the accused. However, in her re-examination, she has said that since I did not arrest the accused, it is not my responsibility to intimate the relative of the accused.
He's not the arresting one.
Your Lordship, then there is no other arresting officer who is mentioned in the case.
No, this is PW1 only.
PW1.
Yes, because this person was already brought in. He was detained.
He was detained, yes.
Paragraph 2, she says, he or she.
She.
On 27, while I was on duty at Lunglai police station, so-and-so appeared at the police station and verbally reported that they had detained one person.
Yes.
So he was already detained, who was suspected to be carrying some contraband items. Then they said information was recorded and was conveyed to the OC, and as per authorized by officer in charge, self with party, rushed to take necessary inquiry.
Yes.
So after the detention, on reaching, we knocked the door, so-and-so trying to find people. Then they gathered the people, and then they started searching. The accused was carrying dark brown color rucksack on his back. I informed the ground of apprehension. Here she is saying, and further informed him that he was suspected of keeping. So she arrested. I stated to accused, and what she may have meant is that she did not, it's not she who picked him up from. Afterwards, she's done it. She said here. I stated to accused and witness that there is no time to obtain search warrant, hence I prepared grounds of belief and they put their signature. This is done. This is okay. You see, you may not find absolute, the conformity with all the procedural checks, but substantial compliance. Here she's arrested it because she was not the person who picked the accused.
Yes.
He was already picked up by another officer. We'll see PW4 when we go there. Yes, carry on.
Yes, Your Lordship. At page 27, Your Lordship.
Is PW2, Caesar witness.
Seizure witness. I know the accused person who is present in
Mr. Lalremenga, you are waiting for another hearing matter.
In fact, Your Lordship, Mrs. Mary, she's on the other side, so I don't think we can take up.
Which is your matter?
Item 18.
Then I can,
Yes.
you want it on another date?
My junior will be here, my lord.
No, if you want, I can give the order right now.
Yes, Your Lordship. It may be taken up after, if possible, after 1 week, ma'am.
In item 18, part 2. I heard Mr. B. Lalremenga, Learned Counsel, appearing for the
Appellant.
appellant on the since MS Mary, Learned APP, for the state respondent is unwell today. The matter stands posted on such and such date.
1st of June.
Your Lordship, if I may continue. I know the accused person who is present. We are living in the same locality. On 27/6 at around 1 to 2 a.m., while I was sleeping, police personnel from Bloom Lake PS came to our residence and stated that one person was detained near the constructing house of Poo so-and-so on suspicious ground. They requested me to witness the search. My neighbor Vanlaru at the silo came with us. I saw the present accused Ram Nunmoya detained by police at the veranda of the construction site. He carried one brown color rucksack. Inspector C. Ram Nunmoya prepared one paper for conducting search and seizure, and I put my signature. Before conducting search, the searching party offered their body to be searched by the accused, but he declined. The police told the accused to put down the bag carried by him. He then put the bag on the floor. The police conduct search of the rucksack of the accused in our presence. Inside the bag, there were 28 soap cases of different colors. The soap cases were opened one by one, and inside each of the soap cases, there were transparent polythene packets containing suspected heroin. Weighing was done on the spot. The total weight was around 351.5 grams. Inspector Siram Nunmoye seized the contraband drugs in our presence. They put the seized 28 soap cases of suspect heroin in the same rucksack, and the said rucksack was sealed with wax. We put our signatures as witnesses on document prepared by the seizing officer. After that, we followed the police personnel to Lunglei police station and they record our statement. Cross-examination is at page 28. I do not know the one who called me up on the said night, but I know he was a police personnel. I know that the police personnel is a member of a team led by Inspector Siram Nunmoyi. Other than what I stated in my examination in chief, the police personnel did not ask the present accused any question in my presence except his particular details. Other than Inspector Siram Nunmoy, there are no officers present at the time of the incident. I do not remember exactly who opened the seize article, but I know Inspector Siram Nunmoy was one of them. It is a fact that the police present on the night were the team member of Inspector Siram Nunmoy. I still remember the color of the seized rucksack, and it was brown in color. I see the color of the suspected heroin, and it was yellowish. I see the weighing machine used, which was digital one. Before weighing the seized article, they did not show accuracy of the weighing machine. I witnessed the seizing of the suspected heroin as I was requested by the police personnel who came to my residence in person.
Yes, go on.
Yes, Your Lordship. Page 29 is the evidence of
Yes, carry on.
Valarwata, who is also a seizure witness. I know the accused person who is present in the court today. I lived in Rasiviang with my family. Before this incident, I am acquainted with the accused as we are living in the same locality. On 27/6/2020 at around 1 a.m. while I was sleeping, police personnel from Lunglei PS came to our residence and stated that one person was detained near the constructing house of Lordship. This is exactly the same as the examination in chief of the
Okay.
previous seizure witness. Cross-examination at page 30. At around 1 a.m., I was awoken by police personnel, but I do not remember the police personnel in person. The police personnel already reached the place of occurrence before we reached the spot. I do not remember the name of the police personnel present at the place of occurrence. Body search was not conducted upon the accused. The seized articles are weighed on the spot, but I did not see while they are conducting weighing. I do not remember whether the police carried weighing machine or not, but at the time of weighing, it was there. While sealing the brown bag by the police personnel, they sealed upon the zipper with wax, but I do not remember the shape of the seal used by the police. Grounds of belief was written by Inspector Siram Nunmoy. After packing and sealing was done on the spot, I believe it was Inspector Siram Nunmoy who arrested the accused, as she was the only officer present on the place of occurrence. After arresting the accused, we followed them to Lunglei police station, and Inspector Siram Nunmoy immediately recorded my statement. I do not remember the color of the seized article. In your Lordship, page 31 is one defense evidence. If I may skip to page 32. The position of PW number 4. I know the accused who is produced before the court today. I am working in CID SB as sub-inspector. During that period, we know that demand of illicit drugs was so high and were not easily available on the street due to COVID-19 total lockdown. As such, from our superior, we received instruction to conduct duty at the night time regularly. From rumors, we know that drug peddler used to distribute at late night. As such, we conduct duty from 9 p.m. usually. On 26/6/2020 at around 11:45 p.m., while we were on patrolling duty, we saw one person at Rasiveng near so-and-so residence, where there is an ongoing RCC construction, carrying rucksack on his back, coming towards us from Venglai. We inquired whether he has permit to move at night time, but he did not have any, and he looked intoxicated from his appearance. As such, we apprehended him, as we suspected from keeping illicit article. I then went to the police station to report the matter, while I led my team member to apprehend the said person with instruction not to conduct search in any manner. Then I gave information to second OC of Lunglei Police Station, Inspector Siram Nunmoy, who was called to police station by the duty officer. I brought the second OC and her team with civilian witnesses who were called by her to the place where we apprehended the present accused. On reaching the place of occurrence, Inspector Siram Nunmoy conducts search of rucksack carried by the present accused on the veranda of the said ongoing RCC construction. Inside, there were 28 soap cases, and on opening the said soap cases, I saw a powder suspected to be heroin. However, I was not present at the time of weighing. Another procedure was taken, as I have my own duty to other place and left the place with my team. Later, I was called to Lunglei Police Station, and my statement was recorded by Inspector Siram Nunmoy. His cross-examination. I am ASI of police at the time of incident. I saw the present accused carrying rucksack at public place. At the time we apprehended the accused, there was no civilian witnesses. I believe there was no chance to exchange the rucksack carried by the accused with other rucksack while I went to the police station to report the matter. I do not remember the duty of officer specifically, but I know he was a police officer. Maybe he was a sub-inspector of police. Information may be recorded by Inspector Siram Nunmoy. After that, they called civilian witnesses, and I waited at the police station. Then, after the witnesses reached police station, we moved towards the place of occurrence together with them. At the time I gave report, the OC was not present at the police station. OC was not present from the time I gave information till we reached the place of occurrence. It is a fact that my statement was not recorded on the said night. It is a fact that before we apprehended the accused, we entered some other residence without conducting search. We do not have any search warrant on that night. As far as I know, before seized article was recovered, by Inspector Siram Nunmoy, the said seized article was not recovered by anyone. At that time, I also have the power to conduct search and to arrest the accused. And page 34 is the position of PW number 7, who is the case IO in the instant case. I know the accused person who is present in the court today at the relevant time. Page 34, Your Lordship.
Is the IO? He's the IO, correct?
Yes, Your Lordship. I know the accused person who is present in the court today. At the relevant time, I was posted at Lung Lei Police Station as Sub-Inspector of Police. On 27/6/2020 at around 2 a.m., Inspector Siram Nunmoy seized 28 showcases containing 351.5 grams of heroin suspected of heroin near Convention Center, Veng Lai, which is a public place. In this connection, she apprehended P. Siram Nunmoya and she submitted a report of seizure and inquiry to OC Lung Lei PS, which was registered as so-and-so, and I was endorsed to investigate the case. During investigation, I examined the complainant and I recorded her statement. I arrested the accused P. Siram Nunmoy and gave arrest intimation and ground of arrest to the father of the accused. I sent the accused for medical examination and received his medical report. I interrogated him and he admitted his guilt by stating that so-and-so. I recorded his statement on the next day after conducting further interrogation. I prepared inventory and drawing of sample was done before magistrate and photographs was also taken. I submitted forwarding letter to send sample to FSL Aizol through OC Lung Lei. I also submitted a prayer to remand accused for 48 hours in police custody. My prayer was allowed and further interrogation was done. On 28/6, the accused was brought to different locality like Bazaar, Setlun, Electric Veng, San Maria, etc. to search for the person who handed the rucksack, but we could not find him since the accused did not know the identity or particulars. I sent the accused for medical examination again on 28/6/2020. On 29/6/2020, I submitted prayer to remand the accused for judicial custody. On 9/7/2020, I received FSL report which shows that the exhibit contained heroin with purity of so-and-so. On so-and-so, I submitted requisitions for CDRs of accused and his parents to SPCID Aizol. Accordingly, I received CDR on 24/7/2020, but from the CDR, I could not find the involvement of his parents or other persons. On receiving FSL report and on summing of other collected evidence, I find a prima facie case under Section 21C NDPS Act for possession of contraband drugs against the accused P. C. Ramnan Moya. I therefore submitted charge sheet accordingly. And cross-examination is at page 36. I do not know what the CID duty who detained the accused on that night. I do not even know their numbers. I do not know whether the accused tried to abscond at the time of arrest or not. I do not know perfectly whether one of the CID ASI Silal Remruata has authority to conduct search or not. I do not know whether
Evidence. You've been caught red-handed. That part has been proved by PW4, PW1, PW7, the IA. Why is it 7? It's not going seriatim. That you find out, huh, Miss Linda? Why is it PW7? 1, 2, 3, 4, and then 7, nah?
5 and 6 were the
They are-
FSL expert and the judicial magistrate.
They are not in the paper book.
They are there, my lord. They are the prosecution witness, but
The evidence was not
this
taken.
time it was COVID pandemic.
So therefore they
maybe-
did not come.
Yes, they did not.
But anyway, that substantially the persons who were required are all there. It is the quality of the evidence that is ultimately material. And any procedural non-compliance per se will not be fatal to the prosecution case unless you show that it goes to the very root of the case or that such procedure is held by the apex court to be mandatory. Gurbakh Singh says these procedures are not mandatory, they are directory. Those section 51 and all that. So I am indicating my mind to you. I'll come in 5 minutes.
Yes, Your Lordship.
Wait. Yes.
Shall I continue with the 313 examination?
Yes, please.
From page 4, Your Lordship.
Yeah. Your difference is that you are a drug consumer, but not a peddler. Correct.
Probably, Your Lordship, in the let's see the 313 examination.
Even I'm addicted to drugs. I never deal in selling or transporting the same. I never receive profit from transaction of drugs. This is your defense. Fair enough. You cannot be convicted of consuming drugs under this provision. It seems the accused is being very fair. In fact, the detaining officer, when he first saw the suspect, because it was during that COVID pandemic time, he was moving with a
Bag.
with that sack. And on stopping him, he suspected that he was intoxicated with drugs. That is how everything started. Later on, while searching, in accordance with law, they found those 26 soap cases. 26, no?
28. 28.
28. Quantity is heavy.
350 grams.
Difficult for you. The points urged by you is appreciated, but then to hold the conviction unsustainable only on that when there are very sterling evidences to show that he's involved. Because the presumption is heavy on him, section 37, he has to rebut it. Correct. That he has not brought any evidence. His father has come as a defense witness.
No substantial.
No substantial. His father says his mobile was stolen and all that. How is that matter? Yes.
Yes. I may read, Your Lordship.
Okay.
First question at page 4. It is in evidence that on the night of 27/6/2020, during total lockdown due to pandemic, you were detained by CID staff Lunglei on suspicious grounds for carrying contraband drug near the.
You don't have to read the entire 313. Any specific answer you want
Your Lordship,
to bring
question
it to
number
the-
6, if I may bring your
Yes,
attention
please.
to question number 6. It is in evidence that during interrogation, you admitted your guilt and stated that the rucksack containing heroin was given to you by your acquaintance who is a drug peddler at San Mari and told you to deliver to Rasivem for 20,000 rupees as a reward. What?
So you see, he admits.
No, Your Lordship, in this.
No, he admits that the rucksack is his.
Yes.
He says, I do not know that the rucksack contained heroin at the time I was asked to deliver the same.
Yes, Your Lordship.
And I was no even promised to receive so as reward. So he admits that the rucksack that he's carrying
Yes.
is his. He does not deny. And the fact that it had that heroin is also now admitted, though he says he didn't knew it while taking it because someone told him to deliver. He was merely transporting.
Yes, Your Lordship, but in that regard, I have one citation which I will come to later regarding
yes,
conscious possession.
Yes.
And question number 8.
Yes.
It is evidence as granted by you were remanded into police custody, so and so. Then you were brought to different localities by police to search for your acquaintance whom you said to be the owner of the seized rucksack, but you could not find him since you did not know the identity.
So
It is
these
correct.
persons were not found.
It is correct to some extent. Even I was remanded in police custody for a period. I was not brought to different localities by the police to search for the owner of the rucksack. In fact, I gave the name and address of the accused, accused as in accomplice, I think here.
Yes.
Kislal Mahmoud Sanman. So my contention from the 313 examination is that although yes, he was in possession, but there was no conscious possession on his part to.
Is a conscious possession? The fact that he was carrying it automatically links it. It was heavy on his part. He has not brought in anyone that so and so had given him. Who is it so and so? That so and so has not been found by the police.
Yes, Your
All
Lordship.
that has not been proved.
Yes, Your Lordship.
An admitted fact remains. The rucksack with the heroin. That's an admitted fact. Isn't it?
Yes, Your
Coupled with that presumption that comes that can be drawn under the Act, statutory presumption. What is wrong in the conviction? How did the trial court proceed?
As in, Your Lordship,
How did the trial court proceed? Trial court's judgment.
judgment is a.
I think as far as evidence is concerned, you have touched everyone.
Yes, Your Lordship.
Nothing is left, isn't it?
Yes, Your
So
Lordship.
let's see the trial court judgment. Where do we
Page
find?
94 onwards.
Page?
94 onwards.
You can come to the relevant part.
The relevant part is from page 108, Your Lordship.
Yes.
Yes, if I may read, Your Lordship.
Yes.
Point number 1, whether the investigating agency had committed any procedural.
Where?
Page 108.
108. Yes.
Findings and reasons.
Yes.
Point number 1, whether the investigating agency had committed any procedural irregularities which vitiate the proceedings or not. Regarding this point, PW number 1, the seizing officer, Mrs. Siram Nunmoy, Inspector of Police, received information from ASI Silarem Road at police station stating that one person is detained at Rasibeng Lunglei by CID staff who is suspected to carry contraband articles. She reduced the information in writing and submitted to OC Lunglei Police Station, who in turn issued authorization in her favor. Here, Exhibit P4 is the information recorded with her signature on the document, and Exhibit P5 is the authorization issued by OC, which are exhibited. PW number 1 further stated before court that with her party rushed to the stated place, and on the way she tried to get civilian witnesses but only got one civilian witness as it was late night and due to COVID-19 pandemic. And on reaching the place of occurrence, she
All
put.
that is not important. Page 113, paragraph 30 would be important.
113. Whether the seized 351 grams of heroin was illegally possessed by accused P. Siram Nunmoya or not. PW number 1, Inspector Siram Nunmoyi, the seizing officer stated before court that seized articles was recovered from the rucksack carried by the present accused by stating that I told him to put the rucksack down on the floor and then we conduct search of the rucksack of the accused in presence of accused and witnesses under proper light. Inside the bag there were so and so cases of different colors wrapped in black sellotape.
I've seen it. It seems the trial court has also acted on your 313 answers also. Couple of the fact that the seizing witnesses and the detaining officer and PW1 all has proved. What remains? I don't find any illegality or infirmity in the trial court judgment
Your Lordship,
convicting you.
Your Lordship, if I may state a few points. Firstly, I would.
Don't repeat it. You want to rely on any authority?
Yes, Your Lordship.
You have already summed up your main argument points.
Yes, Your Lordship.
I've
And
taken note of it.
what I had not mentioned earlier was that in the charge sheet there is no record of Malkhana receipt or go down receipt.
That's all right. Have you taken all these points in cross?
The trial was not taken up by me. Your Lordship. It was taken in a different district.
So in that situation too, there will be never any foolproof conviction. Tomorrow before the apex court, the Supreme Court counsel will come up with so many points and then say, oh, I did not conduct the trial.
However, Your Lordship,
We'll have to see what was, whether these questions were put before the prosecuting witnesses or not, whether the prosecution witnesses testimony has gone unchallenged or not. These are the things we have to see. These things were not put.
however, Your Lordship, what I just mentioned, the Malkhana and go down receipt are supposed to be part of the charge sheet, which is not there entirely.
But these questions were not put. These are procedural. They're procedural defect. You have never put them during trial.
That is there, Your Lordship.
You see, you may be correct. There may be some procedural lapses. But ultimate test is whether such lapses would be fatal to the prosecution case or not. If all procedural lapses are not fatal. The air conditioners are not working. There's the power failure. So the ACs don't work in the generator. It's quite warm today.
Yes. Your Lordship, if you may bear with me, I just have a few citations which I would like to. I have given to the court master.
Yes. Why don't you? Even those fans don't work. Do you know the fan? They don't work. Are you all not feeling warm? Okay. Yes.
Yes, Your Lordship, the first citation which I would like to rely upon is Alamo Lotha versus State of Assam, 2013.
Which one? Which one?
2013, Volume 3, GLR 301. I've written it in pen because the
2020.
2013. The citation I've written, I handwritten.
Yes. The first page is missing.
Yes, Your Lordship. But the name of the case is written in the second page onwards.
Yes.
Yes. Para 12 of the judgment, Your Lordship, 307, page number 307.
This is what? Division bench or single bench?
Single bench, Your Lordship.
Huh?
Single bench.
Yes.
Yes, Your Lordship, in para page number 307, para 12. If I may read.
Yes.
As stated earlier, the seized contraband were produced before the CJM only on 16/8/2006. The prosecution has to explain how it could be produced after a gap of 2 days. The prosecution has to explain where and how the seized contraband articles were kept after being seized on 13/8/2006 at 3:30.
But you have not brought all this on your during cross-examination.
Your Lordship, even if that is the case, the prosecution has also not brought on record
No,
as
it
to
is
how.
not required. That's not, unless you challenge it. These questions has to be put.
Lordship, it was never brought at the time of examination. That it was the Your Lordship in that
Is it
regard.
that link? I understand what you're trying, but these things has to be brought in by the defense counsel. An opportunity has to be given to the prosecution witness to explain these lacunas. That was not done.
Your Lordship, in that regard, if I may refer to a different case, 2000, I have also provided that case. Hanif Khan versus CBI, 2023, paras, volume 6,
Yes.
SCC 709.
Yes.
Page, from page 711.
Yes.
From para 8, Your Lordship.
Yes.
If I may read, we have considered the submissions on behalf of the parties. The prosecution under the ND and PS Act carries a reverse burden of proof with the culpable mental state of the accused. He is presumed to be guilty consequent to recovery of contraband from him, and it is for the accused to establish his innocence, unlike normal rule of criminal jurisprudence that an accused is presumed to be innocent unless proved guilty. But that does
That's
not...
all right.
No.
You see, prosecution has to prove the foundational facts. That general burden of the prosecution to prove its case beyond reasonable doubt will always be there. That's the basic cardinal criminal jurisprudence.
Yes, Your Lordship.
There is no quarrel to it. That the prosecution has done in your case. PW1, PW2, PW3, PW4. They have brought it. Now it's up to you. The foundational facts, they have proved it. That you were caught with the rucksack. Inside the rucksack, there were 28 soap cases. They were being seized. The samples indicates.
Your
these
Lordship,
things have been
that is
proved.
the question I am also posing, that the samples were not properly examined. That the list of samples...
But something more has to be shown. I don't think.
Just because the alleged contraband substances were caught from his possession does not absolve the prosecution from proving that the seized contraband substances were in fact heroin or some other
That
contraband.
sample has been drawn.
Sample has been drawn,
Forensic report is
but my submission is that, Your Lordship, the samples drawn, there is no proof that the samples were actually drawn, because none of the witnesses have stated that the said samples were drawn in front of the magistrate, so and so, or neither the magistrate nor the forensic expert have been examined before the court. So there is no proof
but,
that
the PW4 has said, na? Come to PW4. Come to PW4.
PW4 is at page 32.
PW7. Para 3. I recorded his statement on the next day after conducting further interrogation. I prepare inventory and drawing of sample was also done before magistrate, and photographs were also taken. I submitted forwarding letter to send sample. I also submitted a prayer of remand. So and so, so and so. Exhibits are all there. Exhibits of the inventory 14, photographs 15, photographs taken, drawing of samples. These are all there.
Yes, Your Lordship, in that regard,
You see, this is all there. You can rely on a lot of decisions, but at the end of the day, it has to fit the context of your case. It is not a case where the evidence is lacking. Prosecution has proved its case. Now it is for you, because here you also have a very strict, heavy statutory burden to discharge because of the presumption that is statutorily cast upon you. Correct? Now that you have not discharged. You want some more time, I can give you, but I am not convinced.
yes, Your Lordship, that would be preferable. Your
I am not
Lordship.
convinced. You can give me in a small write-up also your points. We can have it when? Tomorrow?
By Monday, Your Lordship. if
Monday?
possible. Yes.
Monday we can have. Miss Linda, what do you want to say? There is some time before the break. Let me hear you also.
All right, my lord, Monday.
No, let me hear you for a while.
all right.
So that during the weekend I can have the skeleton ready.
My lord.
You see, Mr. Jonathan, prima facie, I'm of the opinion that the appeal will not stand. However, if you come up with something more, I'm giving you that chance for Monday. In the meantime, I'll dictate the factual aspect of the matter, I will not conclude. I will wait for Monday to conclude.
I'm obliged.
That much only I'm going to give you. But you have to also understand that you do have certain shortcomings in the matter, because in such criminal matters, this court cannot act on what is exchanged across the bar.
Yes, sir.
Things has to be on record. Case has to be decided on the basis of evidence. If you have not cross-examined, if you have not put these questions, now you cannot say that this was not done, that was not done. And it is not for the prosecution to come and show everything, that here I am holding the authorization letter, here I have done this. It is assumed that they have done all this.
Yes, sir.
Because crux of the matter is that they have said that these are the things I have done. I have intimated, I have taken authority, I have arrested, I have called for surgery, the witnesses, samples were drawn. They have given. If specifically you want to say, no, this was not done, then it is for you to show that cross-examination is lacking.
Yes, sir.
That's the problem. Yes, Miss Linda.
Yes, my lord. Like my learned friend has already stated, my lord, the appellant was apprehended on suspicions by PW number 4, and this PW number 4 has given information to the second OC, who is the informant in this present case. And my lord, after all procedure were complied, my lord, they have taken samples. Even the appellant himself has admitted the samples were drawn in front of him, and inventory was prepared. They were taken to magistrate. Everything was done as per the procedure. And my lord, there is no lapse in this, because my lord, FSL, it was sent on the next day at page 65. Page 65. This is dated the same day, my lord, 27/6/2020, and the OC has written a letter to the director, wherein
same date.
Yes, same date, my lord. There is no lapse at all in this case. So it was sent to the FSL, and the FSL report came back positive. So, my lord, there is no procedural lapse in this case at all,
and most important, he admitted that the
yes, that's what, my lord. Yes,
in the rucksack. Only thing he says that, well, he didn't know it. Now, in that case, he had to prove it, that it was someone else who had given it to him for delivery.
That is what. And my lord,
who's that person? Some ghost. That person is non-existent person.
With regard to that,
the police could not find that person.
That's what. With regard to that, my lord, I like to say that the essay was recovered from his possession. There was no doubt about it. He has already admitted it, and it's for him to prove that it was not in his conscious possession. And he has named one person. And at page 35, this is the IO, the position, my lord. He has stated that on the next day, that is 28/6/2020, at page 35.
Yes.
On 28/6/2020, the accused was brought to different locality like Bazaar, Setlun, Electric Bank, Chan Mari, etc. to search for the person who handed the rucksack. But we could not find him, since the accused did not know the identity particulars. So, my lord, he was taken to different location to locate that person.
I think I can dictate it now.
Lordship, if it may proceed as what was stated earlier, if I may be given time.
All right. I will give it to you.
I'm obliged to.
But not for re-argument. Huh?
Yes.
Arguments are over.
Yes, Your Lordship.
Additionally, you want to show me something.
Yes, Your Lordship.
Because you see, judicial time also has certain value. So I have given you a patient hearing.
Yes, Your Lordship.
If you want, you can, for your own academic purposes and for satisfying yourself, I'm giving you the time.
Yes.
You look into it. If you come across something, a more authoritative judgment, and because these procedures which you are saying, these things have to, you may find some decision of the apex court where procedure was not followed and the conviction set aside. But that's to fit in the context of your case. In your facts, these things are not brought out. So you be fair to the court also. Okay?
Yes, sir.
Because in criminal cases, I always believe that we all are trying to search the truth. Be it the defense lawyer, be it the prosecution lawyer, be it the court. At the end of the day, we need to ensure that no innocent person is convicted and no guilty is set free. Correct? That is what we need to ensure. So you be fair to the court, you look into it once again. If there is something, you let me know on Monday.
I am obliged.
Arguments concluded, however, at the request of Mr. Jonathan so-and-so, learned counsel appearing for the appellant, the matter stands posted on such and such date to enable the learned counsel to apprise the court as regards any additional point to apprise the court of any authority in support of the submissions made before this court, if available.
25th May.
But you give me a small note of your arguments. Huh?
Yes, sir.
Ms. Linda, you can also put it in a piece of paper if you want to specifically say something on those 3 pages. You can give it to the court master tomorrow also.
All right.
You can also give it to the court master tomorrow, your note, because then I have the weekend to prepare the skeleton.
Yes, sir. Your Lordship, the write-up should be what was stated today or only the additional...
No, to whatever you have said today, those points, because it will be easier for me to put it in the... Okay?
Yes, sir.
And if in addition you get something, then you incorporate it and you say you can submit it on Monday.
Yes, Your Lordship.
This decisions he has given, but just ask. Please indicate the para numbers of these judgments. Also, try and have a look at this decision. This is a division bench judgment where I was also one of the bench partner.
Yes, sir.
This is Vipin Kumar and another on Criminal Appeal 171/2023. Please show it to me. But you return this back to me.
So anyway. 171.